May I please allow you? After the petitioner is aggrieved by an extra 11 my lord, that's a demand notice my lord. My grievance is threefold my lord. First, my lord, the demand notice is arbitrary and unreasonable my lord. It violates the tender terms and conditions my lord. And third being my lords, the principle of natural justice has not been followed before passing this order my lord. An extra 11 my lord. A brief facts regarding this case my lord. The petitioner was the L1 bidder, was allotted the work for implementation of this my lord. And annexure 3, my lord, that's page number 162 is the letter of intent, my lord. This was for the redevelopment of a slum cluster, my lord.
Correct.
Mandap Basti, my lord.
Correct.
Though it was allotted in 2015, my lord.
Yes.
Next, my lord.
And what was the period for completion of the entire project?
That, my lord. The lordship may kindly come to page 44, my lord.
That's the tender document.
Yes, my lord. Page 44, my lord, clause 1.4.
There was any work contract which was issued later on?
No,
letter of intent?
No, my lord. Letter of subsequent letter of intent, no contract, my lord.
No, letter of intent itself is a contract, sir.
Yes, my lord, please.
So,
Lordships, clause 1.4, my lord.
of
read that
page
44 of my paper book.
Yeah, no, 44. Instruct.
I agree, madam.
So,
Or
20
from
months.
the date of handing over of the site by BNR to the contractor.
Whichever is letter.
Madam.
Correct.
It's a slum dwellers were residing, my lord. It was the duty of the opposite parties to hand over me the site free of encroachment, my lord. The
where it
fact
says
is that
was it a as is where is basis the tender?
yes, madam.
Was it as is where is basis?
Yes, madam.
So you knew that these are occupied by the slum dwellers?
Yes, madam.
So you were aware?
Madam. It was the duty of opposite parties to handing over my site, my lord. After removing the encroachment, then my duty starts, my lord.
Mr.
Lordship, in the year, my lord.
Questions look very.
Yes, madam.
That's both. Have you understood and replied?
Yes, my lord. My humble submission is that, my lord, it was enforced by the slum dwellers. It was the duty of BNR.
When you participated, you were aware that it is occupied by the slum dwellers.
But it was the responsibility of the BNR.
Where is that? Because it was there. Is handing over the site with the occupants. That's the slum dwellers.
My lord.
That was given to you at the letter. Where is the letter of intent?
Letter of intent, my lord. That's 162, my lord.
162. Yes.
Annexure 3. And it's an admitted fact, my lord, until 2021, my lord.
Yes, 1 minute.
Yes, ma'am. I'm sorry.
So it was very much clear in the letter of intent that you'll have to start the work. That means that shows that the site was made available to you.
My lord, what I submit, my lord, there were 5 blocks. 1 to 5. For the block 4 and 5, my lord, the site was handed over to me in 2016-17. For which the work has already been completed and handed over by 2019, my lord. Regarding block 1 to 3, my lord, page 172. There itself admitted fact by them that until 2021, the encroachment was not removed. Page 172, my lord.
After receipt of letter of intent,
my lord,
in 2015,
my lord,
have you raised any objection?
Yes, my lord.
That it should have been free from all inconveniences and you have not handed over
series, my lord.
Because letter of intent says within 3 working days or 3 days, you have to start the work.
My lord.
In 2015 itself.
My lord, please.
So,
Lordship may kindly see annexure 1, page 164, annexure 4 series, my lord.
Sir, 172, you are referring it that there are a clear stipulation made by them.
Yes, ma'am.
That it was made available to you with all compliments.
May I read, my
Thereafter, your conduct has been shown.
May I read, my lord? May I read?
I have read it.
Since award of this work,
Yes.
almost 8.5 years have elapsed, my lord.
Okay.
Though the period of project was initially delayed for availability of clear front.
No, the period was initially delayed for availability of the clear front.
My lord.
But
Since
last 3.5 years,
Yes, my lord.
entire clear front was made available
Yes,
to
ma'am.
you.
They admitted
Till date, some pending works of 3 blocks, plastering and an entire
Hello.
finishing work for 2 blocks are yet to be executed from your end. Then come to paragraph, this is just after this paragraph 5.
Soumik, I'm coming to that, madam.
But after repeated
ma'am.
persuasion from our end,
Yes, madam.
no effective productivity was observed at the work site.
I'm coming to that.
That means the site was
Yes.
made available.
2021, madam.
Mr. Such and Such became non-responsive
My lord.
to all our telephonic communications, except 10 workers engaged for some insignificant works.
Lordship.
No site activity was observed as on date.
Lordship, now I'm coming, my lord. What the reason why this letter was issued, my lord? Lordship, there was a Lordship in the 2015, my lord. Lordship, may kindly allow me 2 minutes, my lord. It was allotted in 2015, my lord. They admitted that in 2021, clear site was provided to me, my lord, which is again not true, my lord. Next, my
It
lord.
is a disputed fact.
Yes, my lord. I'm coming to that, my lord.
So,
Next, my lord. In 2021, when I started working for the rest of the plots, my lord, there was cost escalation, which was within the tender terms and condition. I wrote to them, Annexure 7. They never replied to it, my
that is a
lord.
different issue. That's a different cause of action. You are not pleading that.
Lordship,
You are approaching the court against an order of termination.
no, my lord. Not just termination, my lord.
What?
Demand notice also, my lord.
That is what is there.
Yes.
Demand notice means the termination.
Termination, my lord.
So,
Lordships, what I'm submitting, my lords, is demand notice, my lord. Lordship,
price escalation, that is between them, and there must be an arbitration clause.
Lordship,
I think in every contract nowadays with the
Lordship,
On page 109.
two clauses.
Page 109 has
Tender
arbitration
terms,
clause.
two clauses only, my lord. First, my lord, the clause 115, which is the source of this in notices, my lord. Page 91.
Yes, so the lackadaisical attitude, the dormant attitude which he has shown in not completing, not
Lordship, they
responding.
never agreed to.
You could have raised
It's
lot
a
of objections.
pre-GST tender, my lord. This is a pre-GST tender. Subsequent to that, I requested for cost escalation, my lord. They never pay heed to my request, my lord.
It's a different issue.
My lord, next, my lord.
That's a
I'm coming
different
to
issue.
Clause 115, my lord. Lordship, may kindly see clause 115.
So we
which is the
will
source of this
simply
notice.
direct them to consider and take a decision about the cost, the price escalation. This clause, let them take a decision. So far as the termination and demand, it will remain.
Lordship, what I'm submitting, my
It
lord.
will
Clause
no
115.
difficulty.
Lordship, may kindly see clause 115, which is the source of this demand, my lord.
Where is,
For a
which
moment,
page?
Page 91, my lord.
91.
Yes,
Okay.
ma'am.
Bring that 91.
But Lordship is page 100, my lord. Clause 115,
Anyhow,
my
bring
lord.
that 100.
Yes, my lord. Cancellation of the contract, full
Please.
or part, my lord.
Yes.
Lordship, next relevant page 101, the subclause B. May I say, my lord, that the risk and cost clause, by virtue of this, they have raised the demand, my lord. What it reads: the accepting authority may, without prejudice to any other right or remedy, which shall have accrued or shall accrue.
Which one? Where from you're reading?
Lordship, after Roman 10, my lord.
Yes.
The first para, which starts with the accepting authority. May I read, my lord? The accepting authority may, without prejudice to any other right or remedy, which shall have accrued or shall accrue hereafter to BNR and BMC, by notice in writing to cancel the contract as a whole or only such item of the work in default of the contract. The engineer in charge shall, on such cancellation by the accepting authority, have powers to, subclause B, my lord, carry out the incomplete work by means of risk and cost of the contractor, my lord. Next one is second paragraph. Any excess expenditure, this is to what extent they can hold me liable, my lord. Any excess expenditure incurred or to be incurred by BNR and BMC in completing the work or part of the work, or the excess loss or damages suffered or may be suffered by BNR and BMC, as aforesaid, after allowing such credit, shall, without prejudice to any other rights or remedy available to BNR and BMC in law,
be recovered from the monies due to the contractor on account, or if such monies are not sufficient, the contractor shall be called upon in writing and shall be liable to pay the same within 30 days, my lord.
It's a liquidated damages.
Yes, my lord.
So
my lord-
what the contract says that you will complete the contract, the work within, say, the price X. You could not.
Yes, my lord.
Now they have to engage another person to complete it.
My lord.
Now that person charges X plus 1.
My lord.
So up to X immune,
My lord.
anything which is plus 1,
Grateful,
they can recover it from you.
grateful, my lord. That's what I'm saying, my lord.
So,
Before passing
so it's a
Annexure
matter,
11, my
so
lord.
let them decide. That's a question of where is the arbitration clause?
Lots of arbitration clause is at my lord, and moreover, my lord, the arbitration clause 109, my lord.
10?
109, clause 126. 109, my lord. After the Supreme Court's decision recently, my lord, by a constitutional bench, this arbitration clause cannot be worked out, my lord.
They wanted to engage themselves.
Yes, my lord.
So where is the difficulty? But the clause would remain.
My lord, my lord.
You can approach under section 11 of the Arbitration and Conciliation Act to have the arbitrator appointed by the court.
What I'm submitting, my lord.
So
Let the
there is
people-
arbitration clause is not invalidated by that.
Let me given a chance to produce all those documents, my lord. Give me all those documents.
Raise
which
that
they have
demand
relied upon, my lord.
before the arbitrator. It's a question of fact. It's a question of fact.
What I'm submitting, my lord. Before passing Annexure 11, my lord, they should have given me a chance to go through the papers which have been relied upon by them, where they say that this is the excess demand, the plus 1, which my lords had rightly pointed out.
Then the definition of a dispute has to be diluted. If we accept your proposition of law, then there cannot be any dispute. It is a dispute which is to be resolved through a particular judicial or non-judicial mechanism. Then one has to understand that what is the meaning of the word dispute. What you say, then it is diluted to a great extent. You can go to the arbitrator, you can ask all those documents that what is the foundation of your claim, show us any damages which you suffered, you can definitely make a counterclaim.
May I submit, my lord? Humble submission is, my lord. This is a public authority, my lord. And any civil consequences has to be a reasonable order and has to be in compliance with natural justice, my lord. What I'm submitting.
Fair laws judgment of the Supreme Court, there are a lot of judgments even for the government. So the arbitration clause is there. If the parties have chosen a particular forum, then why the court will bypass it? Then section 8 will come into play. We are also a judicial authority.
Lordship, then let them consider my submission with respect to Annexure 11, my lord. Let them give the papers. If that is not resolved, my lord.
This is unnecessary. If you say that they have not taken into account this document, they have not taken it out. They can place it to the arbitration.
No, my lord. I'm not saying.
That what access to those they have the copy to that's completely will take into account the evidence and all.
What I'm submitting, my lord. Let them give me an opportunity, my lord. Let them show the papers by virtue they have arrived at Annexure 11, my lord.
No, that's why I'm saying the way the propositions, what is the concept of a dispute is there? A particular claim is made by somebody and the other side is denying that claim, that it is not substantiated by any reasons. That raises a dispute. And if the parties have agreed to resolve the dispute through a particular forum, then they have to approach it. It is not a one-way traffic in that way that they will make a demand in terms of the clause and nobody will ask a question on that demand. They have to prove.
Had it not been a
They
public
have to
authority,
prove
my
by
lord.
an evidence. So they will produce everything. If they cannot produce anything, ultimately their claim will fail.
What is small difficulty here, my lord?
You are really avoiding the arbitration.
No, not at all, my lord. Ultimately, my lord, they both will be going to arbitration only, my lord. What I am saying, my lord, we are trying to resolve the dispute before going into the dispute, my lord. Let them give the papers.
That's what I'm saying. You are trying to give or assign a definition of a dispute, a pre-dispute state and a dispute stage and a post-dispute stage. Then 3 stages.
May
You
I
are
ask-
really trying to assign pre-dispute. The dispute has already risen. I have not come across a pre-dispute raise. Is a pre-arbitration stage I can understand. If the clause says that the parties would go for a mediation first, and if the mediation fails, that can invoke the arbitration. I can understand that the pre-arbitration stage there is a mechanism. But dispute I have not come across. Pre-dispute stage I have not come across.
Lordship, what I am submitting, my lords. We go to arbitration, my lord. But I think gives Lordship may kind of protect me for at least 4 weeks because they will enforce the bank guarantee, performance bank guarantee, my lord.
It will be a greatest injustice one judge can do.
Lordship, complications
If
with
they
the
not
multi-plan.
find that it lacks an jurisdiction to entertain by virtue of an embargo under section E, can it grant any interim order?
Lordship, then at least Lordship, my direct
Can be grant.
Lordship,
We are talking about section 8 because there is already an arbitration agreement.
small prayer, my lord. Lordship, to their demand notice, Lordship, we have already
If
deprived.
they waive it, we are ready to waive. Let them waive.
Lordship,
The arbitration procedure, let them waive. They can waive. No difficulty.
so I will take notice. Let me take notice at least, my lord.
Who is for the other side?
It's for the BNR, my lord. Opposite party 1 is the proper party is opposite party number 2, my lord. BNR. Union of India, opposite party number 1, my lord. Because this is Rajiv
Yes.
Awas Yojana.
Mr. Nanda DSG, are you waiving your right of arbitration?
Lordship, that's
My lord, there is a arbitration clause in page 109,
it's not
126.
necessary.
Are you waiving or not waiving?
For list past time without instruction, my lord, it is not possible.
No. Your decision that you do not want to waive, say us. If you want to waive, say us.
The party to take this is opposite party number 2, my
I
lord.
understand. Union is also made a party. Let them. At least one authority's decision. Let us see.
Yes, Lordship may refer this matter or can issue notice and next day I will be or I take instruction, my lord, 2
So
days.
you are not waiving.
Yes.
You are
This
not
is
waiving. Yes, that's a fair stand. We appreciate it that you are not. Yes, now he's not waiving. Then arbitration clause becomes applicable.
Lordship, what I am submitting, my lord. To annexure 11, I have already given detailed reply by annexure 15, my lord. Let them at least consider
they've come to a
annexure 15,
very
my lord.
premature stage. It is not a stage
Lordship,
to.
it will
It's not a premature, sir. It has matured to a great extent. It has got a lot of prejudice to them. Once the demand notice is raised, that means the cancellation of an agreement and invocation of some of the clauses where he could be put to
the penalty, my lord. Annexure
a financial liability.
Annexure 13, my lord. First they say that the contract has been cancelled, my lord. Then by the annexure 13, they are saying you execute the work.
If that is so, then the
Annexure
section 9
13.
is there. They can go and approach the
Annexure
London
13.
court for filing section 9 application for necessary protection.
Lordship, can you say annexure 13 for once, my lord?
I have seen that.
Yes, my lord.
I've seen
Lordship,
it.
first annexure 11, they are saying,
I am at page 183 and 184.
yes, my lord.
Yes, I've seen
First,
that.
they are saying, my lord, the contract has been terminated. Then they issue a subsequent letter, my lord. By virtue of this, they are saying, complete this work within a stipulated time period, my lord. That's why I'm saying, my lord, this is not only unreasonable but also arbitrary, my lord. They're the public authority, my lord. Case 184, my lord. Accordingly, the balance of the work shall be executed through alternate agencies at your risk incurred additional finance so and so. Please advise that failure to mobilize and requisite manpower, material and plant and machinery to complete the work within 7 days.
This is for in relation to some other work.
Same work, my lord.
No,
Lordship, the subject.
three sites. The two sites you did not touch.
Lordship, first, the letter of intent, same as an extra 3, my lord.
No, I understand.
Yes, my lord.
But they in their letter they have said that
Yes.
block 3 blocks you have done, 2 blocks you did not touch,
Yes, my lord.
and they do not talk about these 2 blocks.
But so once they cancel the contract, my lord, how can they enforce their right to force me to complete this contract construction, my
Which
lord?
one? This.
Annexure 11, they are
Sir,
saying they are
this is-
cancelling the contract.
Then you say
This
that
is for a composite wall.
the partial cancellation is not permissible in law.
So,
Are you
Lordship, we are
contemplating
not
that?
hearing out, my lord. First, they are saying that the contract has been
No.
terminated. You pay a demand amount. Subsequently, my lord, after 2 months, they are saying
Uh, the notice demanding the recovery on a risk and cost clauses issued on 12/5/2025 is a subject matter of challenge in the instrument writ petition. A preliminary objection is raised on the maintainability of the writ petition. Stop. According to this Union of India, according to the Union of India, the demand was raised strictly in terms of clause 126. No, 100, page 109, 11, 1 point.
115, my lord. That's risk and cost clause.
Yes, which one?
115, my lord.
Clause.
Yes, my lord.
In terms of clause 115.
Yes, my lord.
In terms of clause 115 of the contract. And if any dispute is raised in this regard, the parties have chosen a forum of arbitration to adjudicate such issues. It is thus submitted that the writ court should not interfere with the contractual matter in view of the existence of a arbitration agreement. Stop. We find that the Bridge and Roof Company India Limited who awarded the contract to the petitioner is not represented today. Our attention is further drawn to a letter dated, where is that extension? 31st? Page 192. You say the extension of time.
That's not extension of time, my lord.
That is, you just referred the last one.
Yes, my lord. That's my lord. Annexure 7, page 1.
Not 7, sir. You just showed me that it has extended till they asked you, even after termination, asked you to complete the
Yes, ma'am.
which page?
Annexure 13,
13 page.
page 183, ma'am.
Yes. Our attention is drawn to a letter dated 21st May 2025 with regard to the final notice at pre-invocation of a risk and cost clause because of the inordinate delay and the deficient performance in execution of the contract, wherein the time to complete the remaining unfinished work to be completed
Page 184.
to be completed on or before 6 July 2025 in relation to a Mandap Basti Ray project. Full stop. The demand notice is issued on 12/5/2025 within the period of the said extension. So, the question which calls for consideration whether the authorities can invoke the risk and cost recovery clause appended to the contract before the completion of the project within the extended period. Stop. It further raises an issue whether such a factual dispute can be decided invoking the extraordinary jurisdiction conferred under Article 226 of the Constitution when the parties have agreed to resolve the disputes through an arbitration mechanism. Since the other respondents, then the Union of India is not represented, the petitioner is directed to issue a notice upon the other respondents. Requisites to be filed within 3 days from date. Matter is returnable after 3 weeks. For abundant precaution, we hereby made clear that all points, including the point of maintainability of the instant writ petition, are kept open and shall not be deemed to have been decided by us.
There's an interim application. This may
6, 7, you go interim, no, we are not going to.
Item 9.
Obliged man.
Respondents, all the respondents. Yes, call the
Item 9.
Item 9,